Welcome back. In this episode, I will discuss the concept of a medical or hospital malpractice lawsuit, and specifically sticking with the construct of one concept and three underlying elements. We'll talk about the three things that someone would need to prove to make a case against your organization. Number one, they would need to show that there's a violation of or departure from a standard of care. Number two, they would have to show that there is injury that resulted in significant damages. And number three, they need to show that the deviation from the standard of care, and that deviation is negligence, the deviation from the standard of care actually resulted in the damages that occurred. So you might be saying, what? Why? I thought this was a course on cyber risk management. Well, it certainly is. And the reason we're focusing on this subject is because over time we've evolved from this being a matter of compliance to a matter of security to a matter of patient safety, which is where we live largely today, to triggering into a malpractice lawsuit of some sort. And in fact, we've had some near hits, and just very recently, I spoke about it in the last session, there's been a lawsuit charging or alleging wrongful death that resulted from a ransomware attack. So there is a connection between our work in cyber risk management and the notion of a medical malpractice lawsuit. In fact, I've been saying for some time now, I have been expecting a cyber-driven malpractice lawsuit. So why? Just think about this for a moment. A deviation from a clinical standard of care may result in that injury that I spoke about a moment ago. A deviation from a cyber risk management standard of care could indeed trigger a departure from a clinical standard of care. Think about systems and critical data not being available at a very urgent, emergent time. And number three, think about the fact that while I don't think we have it codified in law at this point in time, there are a lot of emerging standards of care around cyber risk management. The HIPAA Security Rule, for example, is a floor. The NIST Cybersecurity Framework, which is being widely adopted in all industries and notably in healthcare, is a standard of care. Think about all the OCR enforcement actions that have been undertaken. There are over 100 documented such actions right now. They form sort of what one might call common law or case law. And then last but not least, the work products that have been produced by the CISA 405D work group have been cited in HR 7898 as an example of a certain recognized security practice. So there is tight linkage here, and we will be exploring those elements under the concept of malpractice as we go along. As a quick reminder of where we are in our journey, this is episode number 4. What we intend to do is achieve our overarching objectives that I presented in the very first session by way of going through all these episodes, cover the themes, and we're going to do it in the form of brief, digestible episodes like the ones that you see there. As I mentioned, I'm currently contemplating between 25 and 30. In fact, I'm at 30 at the moment, but probably will flex to delete, add, change as we go along. All of the episodes are loaded into or onto this YouTube channel from which you're viewing this session right now. If you've not already done so, please subscribe, and you'll be notified when new episodes or other content is posted related to the episodes. And then finally, feel free to share this information and the YouTube channel with any of your friends and colleagues whom you believe may benefit from it. So I'd like to begin talking about what didn't quite become a medical malpractice lawsuit, but a very personal experience that may tell the story and help you understand. So over the years, I've had a number of lumbar surgeries. 20 years ago, I was facing surgery number 3. I've had a total of 4. And I remember going to my surgeon and saying, I just can't do this anymore. How many more children do you have to put through college? I literally asked him that. And said, I'm going to a chiropractor. And it was against his advice that I did. I ended up having a chiropractic manipulation that ended up breaking a disc in my back. The disc penetrated through the nerve sheath. it cut the nerves that serve and send messages to the tibialis anterior muscle, also known to me as the old foot picker-upper muscle. The upshot of all of this was I ended up with drop foot and ended up with a so-called ankle-foot orthotic. And so let's think about this from the point of view of medical malpractice. I had a lot of friends and family say, well, I hope you sued the guy. Well, I didn't. And here's why. Let's go back to those three elements. First of all, was there injury? Absolutely unequivocally. And to the extent we could have made a case that there were significant damages is another matter. 20 years I've been walking around, I've not let it slow me down with an ankle-foot orthotic. So we could probably prove the first thing. Secondarily, was there causation? Yes, he did it. He manipulated my back that caused the injury. But the last thing, and a critical thing here, was there a departure from the standard of care? And the short answer is no. The chiropractor did what he does. And shame on me and my bad, going against the advice of my orthopedic surgeon, I ended up in the condition I'm in. I've not let it slow me down. I'm fine. I'm not bragging or complaining. But the point is that all three elements must be present in order to prove malpractice. So let's return to the hacked CT scan image. Here's a headline you don't want to see. And just as a quick refresh on this case, we had CT scan images that can, and in the case I presented, were modified. Take the scenario for a moment that the attacker removed cancerous nodules from a CT scan image. That in turn resulted in radiologists missing or being fooled and not seeing any indication of cancer. It happens, and in fact it was demonstrated in that research. Let's say that the patient really did have cancer. As a result of this, did not receive the treatment that they were supposed to receive. And then finally, let's say, sad situation, the patient died. Could this situation turn into a medical, professional, or hospital malpractice lawsuit? Maybe. So let's look at the three elements and think about it in the context of that particular situation. When it comes to a violation of standard of care, the law acknowledges that there are certain medical standards, and think about evidence-based clinical practice guidelines, such as those maintained by the ECRI Institute, specifically within the ECRI Guidelines Trust. So a patient has a right to expect that they are going to receive treatment following certain care protocols and certain standards that have been well established. If it's determined that the standard of care has not been followed, then that can serve as a basis of demonstrating that there was indeed negligence. And that's a very important baseline. I could not, in my case that I referred to a moment ago, I could not prove that there was a deviation from the standard of care. The chiropractor, for better or worse on my part, ended up doing what he does for a living. Let's look at number two. An injury resulted in significant damages. Well, certainly in the scenario I laid out, if the individual died as a result of that misdiagnosis, that certainly is the basis of significant damages. And so why do the damages have to be significant? Well, medical malpractice lawsuits are very expensive, I understand, to pursue. And for the case to be viable, the patient has to be able to show that there are significant damages. In this case, we could probably establish significant damages. And then finally, would be a matter of proving that the damages, the injury, the death resulted from a deviation from the standard of care or from that negligence. Now, this is an unusual case, and I'm not sure how it would possibly play out in front of a jury, but we've got the key thing of proving causation. And so what was the standard of care that would apply here? It's not as if there were any obvious clinical standards of care that were violated. Obviously, as we spoke earlier when we first covered the case, there were physical safeguards that apparently weren't in place. There were administrative safeguards that weren't in place. How'd somebody wander into the radiology department after hours? Clearly, there were technical safeguards that were not in place. So there might be the basis for a plaintiff's attorney to make the strong argument that enterprise cyber risk management standards of care were not being followed. So the key question becomes, what is that relevant standard of care? There are clinical, practical practice guidelines that I mentioned, but mainly I think we'd probably be dealing with cyber risk management standards of care. I mentioned at the onset, and I'll suggest to you again, that there are emerging, if not established, enterprise cyber risk management standards of care. Call them cybersecurity standards of care, if you will. HIPAA is one. Also mentioned the NIST Cybersecurity Framework as another, given its wide adoption around healthcare. Certainly the quote-unquote case law or common law that's emerging out of all the OCR cases. And then also, last but not least, HR 7898, which established certain recognized security practices. The NIST Cybersecurity Framework was cited, and additionally the work by the CISA 405D group. So what we have is an interesting situation that is evolving, and we don't have our handle around it completely or fully yet. But what we covered in this session was the concept of a medical malpractice lawsuit. Remember those three key elements that we discussed. I would encourage you to especially take note of the idea of a standard of care. And then last but not least, within your organization, talk about what enterprise cyber risk management standard of care you may or may not be following. As always, I'm ending the session with suggested actions and references and resources. I would encourage you, while the material is still fresh in your mind, to have a look at some of those actions and perhaps undertake some of them, and also to consult with the references and resources that are provided. There are some interesting ones there, including the Wall Street Journal article about the lawsuit that was recently disclosed regarding Spring Hill Medical Center, and the case itself. I actually have a copy of the complaint there. In the next episode, I'll discuss risk that could ruin your business. We'll talk about three, because I'm trying to stick to my construct: financial risk, reputational risk, and last but not least, professional hospital liability, which we've pretty much covered in this session. Until then, please subscribe to the YouTube channel. Be well, be secure, and I'll see you in the next session. Thank you.